I'm sorry for troubling. I think I requested my learned friend, the other side, item 22 and 23. Yesterday I have sent a SMS to my learned friend, spoken also.
22 and 23.
Some time may be given, my lord, 3 weeks time in this case for filing reply, my lord.
So you're for the appellate
petitioner.
petitioner
Yes, both the case.
in both the matters. Who is appearing for the other side?
The PP, ED is appearing.
PP is appearing.
Yes, on behalf.
Both 22 and 23. I heard Mr. D does the learned senior advocate assisted by as does the claimant counsel for the petitioner come appellate. And also heard
Medoki King on behalf of Kiduri Joso.
so and so appearing on behalf of K. Jotsu, the learned PP. Mr. Das already submitted that sometime time will be required to file their affidavit in reply. Mr. Prayer allowed, list the matter accordingly. You need how many weeks? 2 weeks or 1 week?
3 weeks.
3 weeks.
Yes.
List the matter accordingly to 3 weeks.
Date.
Date you want any specific date? You
Yes, 23rd.
want? 23rd of June?
Yeah.
23rd.
In the meantime, I know there is an interim order which has been passed in which no
22.
No, there is an interim order in revision.
Yeah.
There is an interim order which will be extended.
22, item number 22, the interim order passed in criminal revision petition so and so be extended till next date existing.
In other case, there is already a stay. Yes,
In appeal already stated.
yes, always.
Well, last time as well, my learned friends had sought time, which time has expired. So my only request is if only the shortest possible time is given to them.
I have requested, my learned friend is online, only that some difficulty was there because certain documents we have to verify. In the affidavit, they have brought certain dates, certain numbers, case IA numbers. So what we requested, our learned friend in the trial court to get the certified copy so that we can cross-check and find it out, the affidavit which they have filed, whether it is correct or not. For that purpose, my lord, we are seeking some time.
Generally, the department is not going to file wrong documents from the trial.
I am not saying about, I am not.
Even the presumption under 114E would apply when the department is filing documents.
Whatever may be, my lord, thus I am accommodating some verified trial court record. So 23rd, I am requesting.
Okay, now we are fixing on 23rd of June. That is the fixed date.
Very
So
well. Very
in
well.
that time, because Mr. Das is from outside station, so we are fixing on 23rd.
Very well. My lord, may only observe no further adjournments. That's my only request. Because 4 weeks already granted, they're enjoying an interim order. Now, this is a perpetuating an interim order. And I had shown on the last date, my lord, how some incorrect statements were the basis of an interim order. I will demonstrate on the next date.
He'll be counsel for the petitioner, Mr. Das. He is hereby take all the individuals to file their affidavit in reply.
Yes, yes.
On or before the next date of listing.
Right.
Okay.
Deeply obliged.
Okay.
Deeply obliged.
Deeply.
The appellation lordship. Lordship, I beg to mention item number 19. Lordship, here, I'm waiting for the instruction. So 3 weeks time will be granted.
Instructions in a sense, you have not filed your affidavit.
No, not a filed.
I have no objections.
Heard Mr. Swenson, the learned counsel for the petition. And also heard Mr. Swenson, the learned comment advocate, seeking time to file their affidavit in opposition. Prayer allowed, please do matter accordingly. How many weeks you need now?
2 weeks.
Please do matter accordingly after 2 weeks. Okay, we're listing it after 2.
Worship.
Lordship, I may be allowed to make a mention for item 21.
Item number 21. Yes, it is a revision.
Yes, this is the first returnable debt. Now, as per the last order passed on 2025 by the trial court, the parties, they have submitted before the court that they are willing to go for an out of court settlement. This is a family issue, custody case. So I pray that 3 weeks may kindly be granted, so that the parties will also utilize that time to come to an out of court settlement. And in the meantime, I may also be allowed to file my
Because
affidavit.
one custody case is there. pending.
Yes. And if they come to an amicable settlement, then this case, I believe, will become infructuous by the next returnable debt.
So obviously. So you're appealing for the petitioner here also?
I'm for the petitioner.
I am for the respondent.
Sorry, you're for the petitioner.
I'm for the petitioner.
Yes, the sole respondent.
Mr. C.T. Jamir was there, he's not here.
He is out of station, Your Honor.
Okay. Anyway, heard Ms. So the learned counsel for the petitioner, also heard Mr.
Sendiangan.
Sentigar, the learned counsel for the respondent, and it is submitted that the parties have already appeared before the learned trial court below in custody case number 07, 2023, wherein it is stated that there is talk of settlement of the compromises going. Considering the submission made by learned counsel for 4 sales and the talk of compromise between the parties, let the matter be listed when it won.
After 3 weeks, my lord.
After
3 weeks,
list the matter accordingly after 3 weeks.
deeply obliged.
Okay, if it is there, any kind of settlement is there, then obviously it will become.
Yes, my lord. Much.
So you are supplying this one with us?
Yes, my lord.
In the
Lordship.
case record, item number 21. Item number 20.
I may also be allowed to make a mention for item 30.
30.
Yes, my lord. Here I am yet to file my reply. I am for the petitioners. I have received the RTI information which I have sought, which is more
Now
than.
here, all the respondents have they filed their affidavit or someone?
Yes.
Yes, Your Lordship.
Yes, yes.
State has already filed. it.
State has already
Yes.
filed. Is there, are there any other private respondents?
Private
or not?
respondents have also filed.
They have also
Yes.
filed. So you
Now
want
we
to
have-
file your
Yes,
affidavit in
my
reply?
reply. Yes, my lord. I have sought RTI reply, RTI information, which was replied to me in more than 1,000 page
Reply is
information.
there.
Yes. So which is why I need a short time, 3 weeks, my lord.
Mr. Senti and the
Your
for
Lordship.
the petitioner.
Your Lordship,
Yes,
uh, since the matter is pertaining to this thing urgency, Your Lordship, the time may be shortened to 2 weeks if possible.
My lord, my
Okay,
lord.
In the meantime,
you are Mr.
Peter Sarto, appearing for private respondents,
Peter Sarto appearing for the private respondents and also
7273.
how many?
7273.
7 to 73.
Yes, sir.
All the private respondents and also heard a Ms. So the learned. You are government advocate?
Yes, Your Lordship.
Government advocate appearing for the state respondents. It is submitted by the learned counsel for the petition that all the respondents have already filed their affidavit in opposition. But after taking some instructions, the petitioner is going to file their affidavit in reply. Prayer allowed, please do matter accordingly. After 2 weeks, you say?
Yes,
You said after 2 weeks?
Yes, sir.
List accordingly after 2 weeks.
Lordship, there's an interim. Let the interim
Interim
continue.
order, we continue till next date of listing.
Deeply obliged.
May I please, Lordship, may we please to mention item number 17. 17.
Yes.
On behalf of my colleague AIM, Your Lordship, it seems that Your Lordship, she has filed her additional affidavit as directed by this court on 22/5. However, a copy is yet to be served to the petitioner, Your Lordship.
No, you were appealing for the petitioner only,
Yes, for the state.
state responded.
Yes, Your Lordship.
Oh, yeah, for state, now name
Yes.
has not been reflected in the cause list. That's why I thought that state is not yet appeared. In the cause list,
Yes,
Heard MS. So who is appealing for the petitioner here in item number 17? They're not here.
Your Lordship, I am not aware because I'm appearing on behalf of my colleague, so
No, it's okay. You're appealing on behalf of your colleague that is for state
Yes,
respondent.
yes, Your Lordship, for the state.
So petitioner, item number 17, madam. Item number 17 will come now. Or item number 72, say item number 17.
Item number 17.
Is no one is here, na? Okay. What can we say now? Now they are, I don't know.
Lordship, the need can come after some.
Later,
Yeah.
later we reach then.
Yes, Your Lordship.
Lordship, I have another matter, item number 20. Here also, I am yet to receive an instruction.
In item number 20,
20.
you have not filed your affidavit.
No, I have not yet received an instruction. So 3 weeks' time will be granted, Your Lordship.
Yes, you are for the petitioner.
Yes, Lordship, I have no objection.
Petitioner. And the London government advocate appealing for the state respondent, Mr. So-and-so, submitted that he need 3 weeks' time to get instructions from the department itself to file their affidavit in opposition. To which the London counsel for the petitioner raised no objection. Prayer error, please the matter accordingly. How you 3 weeks' time?
3 weeks.
Is the matter accordingly up to 3 weeks. Enabling the respondent, state respondent to file their affidavit in opposition.
Lordship, I beg the mention hearing item 40. I pray that this matter may be listed on 28,
40.
Lordship.
Otherwise, it was a fixed matter, I think.
Yes, Lordship. But then it will come up on 28. I've taken the consent of the properties.
Concept of the other side. You, Mr. S. Wali.
On 29th, Lordship, on 29th.
29th of this month.
Yes,
Not possible.
Thursday. Oh, then on 28th, Lordship.
It will be on the next week only because what is happening, carrying the bulky record from here to Guwahati will be very problematic for us. So Monday and Tuesday I'm going to here, otherwise maybe pretty difficult on our part also. So let it be on the next week then. Either second, third or this week.
Okay.
Second, what is this second lot of matters been fixed, I think, na? On,
On 3rd, then,
let it be on third, because it is a hearing day also, third.
Lordship.
At the request made by learning council for both sets, list the matter accordingly on 3rd of June, so it's.
Lordship.
Okay, much better. Your Ladyship, I'd like to mention item number 29. I have instruction to appear on behalf of respondent number 3 and 10. So I may be allowed 3 weeks' time to obtain
Three-
instruction.
3 to 10 or 3
3 and 10,
and 3 and 10.
yes.
3 and 10 are the government, state respondents. How many, who are they? 3 and 10?
3 is the commissioner
Commissioner
secretary
secretary.
and 10 is the engineer in chief.
And you are appearing?
I'm for respondent number 1, my lord.
Respond number 1?
Yes.
And what about the rest of the respondents is the 29,
Reliance
29,
also, how about
29,
the 3 and
Regarding the other
29,
respondents,
item number
applicants,
20.
How about Suleiman? How about Suleiman? Oh, 10, 11, 12. Hold on a minute.
We were supposed to file an amended cost title also. That has already been filed.
yes, Lordship. And then according to the applicant steps upon the newly imputed respondents, that is respondent 8 to 12 on 3/10/2024,
8 to 12.
Lordship.
So now all total the respondents are 12,
Yes, Lordship.
12 in numbers. So in some the office note, these respondents, some of the services still awaited for the some of the respondents. So otherwise, 1, 3, and 10, they have already appeared. You have
Yes.
already appeared.
Yes.
You have Mr. Welling,
Lordship.
heard Mr. S. Welling, the learned counsel for the petition. And also heard MSC Supri, the learned your government advocate or additional
Additional AG.
additional AG for the appearing for the behalf of respondent number 3 and 10, and also heard Mr. Swenso, the learned government advocate appearing for the respondent number 1. You have filed already your affidavit in opposition? No.
No, today
No,
only I'm
today only.
entering appearance.
And accordingly, the learned counsels for the respondent submitted that they need some time to file their affidavit in opposition. Further from the further from the office note, it is seen that the service is still awaited for some of the respondents, though it is submitted by submitted by the learned counsel for the petitioner that steps have already been taken for all the respondents, including the newly implemented respondents. Let the matter be listed accordingly. You need 3 weeks or
Yes,
3
3 weeks.
Let the matter be accordingly listed after 3 weeks. And service be awaited for the other respondents till next day. Okay.
Much obliged.
Please, Your Lordship. I beg to mention item 4 to 16, Your Lordship. Kindly this matter may be listed after 2 weeks.
These are all in.
No,
commission
Lordship, I object, Lordship. I object because Lordship will kindly see this matter has been filed on writ petition.
Give me one, item number 4 you give.
My lord will kindly be pleased to hear out my case. This is deliberate
You are appearing on which item?
for the petitioner 4-2. Item number
For all the
4-2,
petitioners?
all the petitioners. Now, my lord, what has happened is this writ petition 340 was filed on 16/12/2022. Then the next batch of writ petition was filed on 3/7/2023. Now, Lordship, what is happening is the opposite party respondents, this is a backdoor appointment. An appointment made without advertisement in class 1 gazetted post, that is assistant professors. Lordship will kindly appreciate that this is pertaining to whole public issue, and recently an uproar was there and awaiting the outcome of this writ petition. What has happened is they have been taking time one after another since there are so many advocates, and it is deliberate, and they are impressing delaying tactics. Now, what has happened is, Lordship, my lord will kindly see since 2022 and 2023, after the case is
These matters have
filed,
been pending.
they have been taking time, and as if we have no other work except manning this case. Now, Lordship will kindly see that if my lord will kindly in 208.
Yes, it is before us.
340. No, there are two. There are two different writ petition, 240. Here, my lord will kindly peruse order dated 11/7/2024. 11/7/2024. That is in writ petition 340. 340.
Item number 5.
I want to impress my lordship. This cannot go on.
11/7, you're saying date is?
That 11/7/2024. I pray before this honorable court for implementation of the last paragraph. 11/7/2024.
Yes.
My lord, 11/7/74, the last paragraph. It is made clear that if no affidavit is filed, this court shall on the next date proceed with the case on the basis of materials available on record after imposing cost. This was passed on 11/7/2024. Because of them not taking up the case, this has been passed. Thereafter also they have been taking time till then. Now, Lordship, one after another, I will just appraise my Lordship. CPC, Order 9 Rule 6.
Yeah, you read it.
Your Lordship. Procedure when only plaintiff appears. When the plaintiff appears and the defendant does not appear, when the suit is called on for hearing, then when someone duly served, if it is provided that someone was duly served, the court may make an order that the suit be heard ex parte. It is in consonant with this order dated 11/7/2024. Then Lordship will kindly, this is the latest SCC, page 32.
No, it's okay. The question is that is they are delaying the case.
They are delaying, that's why.
Yes, and
Just-
on the last occasion that you have already submitted in the item number 4 also, and then again item number 5 also, there are some strict directions
Yes.
from the court. But today, yes, what is the reason why you are seeking time this time?
My senior has personal difficulty because he has a matter in the principal city, Your Lordship. A special
Who is the
division
NK
bench,
senior counsel?
City Jamir, Your Lordship. A special division bench has been constituted for tomorrow and day after tomorrow before Justice Surana and Manish Chaudhary.
So,
What
Lord-
matter is
Yeah,
going on
yes,
in
yes,
case?
yes.
That is
So
within
that is
my
unavoidable.
knowledge.
Otherwise, Your Lordship,
So, Lordship,
Just a second, yes, then,
if you can kindly check the order 29 to 2024.
in which item number?
In item 208, Your Lordship, WBC 208,
Order dated, what's your date?
29 to 24. Hmm.
29/1 or 29/2?
29 to 24.
Yes.
Paragraph 8 will be relevant, Your Lordship. This court made an observation to implead UGC as a party, and accordingly an IA was filed, allowing the impleadment of UGC as a party respondent. And the UGC has not appeared so far.
Lordship, that is not up to
So-
them. I pray before this honorable court, although this honorable court has passed the order, Lordship,
No, my question is that an order was, there is specific order.
Yes.
we
Specific
have-
direction.
IA was
You
also
already
filed.
filed UGC as a party.
Lordship, we have sent UGC twice. Notice has been sent twice, but somehow, Lordship, they have never appeared. So on my part, I humbly
No,
pray
but
that this is
UGC
only,
a, institution, so who will appearing, generally UGC is appeared by any
There's
council here?
no standing counsel for the UGC here in Kohima.
Then is there any provisions that if state government panel it can be?
I don't think the UGC can, state can appear for the.
Otherwise, UGC, pardon,
The UGC will engage its own counsel.
own council, standing council as per your knowledge is not here.
No, none.
But UGC has already been made party here?
Yes,
yes,
through
Lordship,
an IA,
We have
and IA was
sent-
allowed.
I was allowed.
Yes, Lord.
we have sent twice notice through the registry.
So these colleges are already recognized by UGC, I think. That's why
Lord-
the order was passed for making
Lordship,
the party as a UGC as a party.
UGC is only on the issue of salary.
Whatever, they all the colleges are under UGC.
Yes.
Yeah.
The Honorable Court has made an observation to implement
That's
them
why
as a
the
party.
observation was made most probably because they are under the UGC. That's why obviously there was an observation was there, and that's why the UGC was asked to make a party. So now, what is the report? Is there any report in regards to notice to UGC? Office report ki ba ase nahi office note?
We have sent,
UGC is made as a party, respondent number. Yeah. Notice issue. He is a respondent number 12 or what? It's not a line. Yeah, you have already filed your amended cost title also here, no?
Yes, Lordship.
So he is made, the UGC is made as respondent number? It's not here.
Lordship, it will be for 5. In writ petition 188.
But in
Uh,
208
we-
also you were asked to make party here, 208,
208.
because order is there in the 208 also. Do you know who is the part, his response number? UGC is the response number?
I don't recollect, Your Lordship.
No, you have not filed your distance. At night.
In which case this order was passed? Which writ petition?
Common motion.
208.
No, it's a common motion.
Yes.
So
In
common order-
208, it-
common
it-
order in
it was
208
passed in
it was
208,
Yes,
Lordship.
yes. No, I'm searching for who, he is the response number, who is his response number? It's not here.
Lordship, this will be respondent number. Will be respondent number 5, because the Commissioner and Secretary, Department of Higher Technical Education is respondent number 3. The Director, Department of Higher Education, Nagaland Kohima is respondent number 4. So the UGC will be respondent number 5.
Respondent number 5.
Otherwise,
কেনেকে হ'ব? ক'ত আছে? এইটো নাই দেখোন।
thank you.
It's not respondent number.
It will be either respondent number 5 or 8. Below the private
So that
respondents.
means you have not filed your amended cost act.
We
No,
have
they have
lodged-
not filed the
You have
amended
not
cost
filed
title.
that cost title. And from where you are saying that you have taken steps, because note is also not here. As per the office note, I'm saying. Otherwise, other respondents have already appeared, most probably state and other respondents. So here we have not filed any, I mean, I've not seen anything regarding the notice issued to the, I don't know now, at present, we are not in a position to say even
Yeah.
is a response number 5 or 6 or 7 or 8. Because you are not also, is.
There are so many big petitions and.
No, you see the 208 now, 208 order was passed in 208. Obviously, there will be other orders, same order.
Kindly give me 1 minute. Since there are 13 petitions, Lordship, in one petition.
Lordship, there is an IA 31 of 2024 where they were.
Obviously, there was an IA,
Yes.
I was allowed as you have submitted, and accordingly, UGC has to be made party, in
Yes.
fact. Now, by, on perusal of the record, it is not there. Now, who is response number? Who is he is the response number? I don't know. Because in some matters, up to response number 9 is also there. That's why.
And I don't recollect filing an amended cost title
Amended
also
also,
to
we
that
are not
effect, yes.
finding here, the amended cost title is also. I don't know if you can just show me, because
Because I wasn't served a copy of the
I could
amended
not,
petition.
find it. It's not here.
Lordship, we will do the needful and we will check up the registry. As far as my knowledge go,
Check up the registry also.
yes,
Is there any note from the registry regarding the steps taken to the respondent UCC?
we have filed twice.
As they have submitted that they have filed twice, but here is no notice here, in fact, on the registry's note is not available here. নাই ইয়াতে একো। So তাতে পালে চাব লাগিব। It's not reflected here. And moreover, the respondent, who he is a respond number, this is number is also not, you just also check the record, whether any amended cost title is filed, whether any steps have been
Lordship.
taken.
Lordship.
And definitely, you can collect some
We will,
instruction from
Lordship.
the registry also. Otherwise, you see, now she is saying that definitely it is a case of 2022 and all.
Yes, Your Lordship.
There are some illegal appointments or whatever you say, the backdoor appointments are there.
Yes, Your
So
Lordship.
now they are enjoying their service till 2022.
Yes, Your Lordship.
So it's a matter of concern. In fact, it should be disposed of earlier, but I don't know at this stage whether UCG was there or not.
Lordship,
So, no, yes.
can I just submit one aspect? We will check up the registry as well as we have also filed, since we were meant to be, and we have also filed twice the notice through registry. We will check up. Something is very wrong, Lordship. Now, what I want to submit before this honorable court is, if UGC has not received the notice, let the notice be issued in the local daily.
First of all, two things are there.
Lordship.
One is that if UGC has not yet received or if the summons were not received or whatever, that means you can take a fresh steps. But in that apart, your thing is that whether you have filed your amended cost title,
Lordship.
implementing the UGC as a party.
Lordship.
Party
We will,
respondent.
we will
have
check
not
up.
filed it, you check this. And if it is not there, then immediately you can file your amended cost title, text it,
Lordship.
and your order pass will be accordingly.
Let the, then in that matter, let the matter come up on Thursday.
No. We're not going to hear any matter on Tuesday. Monday and Tuesday will be last day for hearing.
Then on Monday, let the matter come up for all this.
Monday, will it be possible for you?
Yes,
Because
Lordship. I will check up. I
you
will
have to
check up.
check up all the records and all, then only, if
Let-
it is not there. I don't think that Monday should be proper. You take just 1 week or 2 weeks. What
Then
you
on
say.
Tuesday, Lordship, I will try my level best
Try.
to
Okay,
do that.
Tuesday, your senior counsel will be also free, I think.
Yes, Your Lordship.
The 2 days hearing are there.
Yes, Your Lordship.
For Palikizaba, hard MSJ Jet Bijomi, the learning counsel for the petitions, and also hard.
I am Jen, Your Lordship.
Huh?
I am Jen.
I am Jen. And the other councils are also. the
Yes,
government
there are
is
several
also
councils.
For the state,
State.
yes, in all the.
Appealing for the state respondents. You are Mr.
Your Ladyship, I am for respondent number, some of the respondents in item number 5, that is 240.
Right.
Private
Some of the
respondent.
respondents appearing on behalf of some private respondents. And you also appearing
Item number 5.
for
Item number, some of the item
some
respondents.
for the private respondents?
Yes.
Private respondent for so and so. Explain Mr. So and so, the appearing for the private respondent submitted that his senior his counsel, Mr. J. Zamir, is out of the station and for which he paid one adjournment. While hearing the matter, it has come to the notice that by the order dated 29/2/2024, an order was passed by this court directing to implead the UGC as a party respondent in the instant case. Accordingly, the one I was filed and he was directed the UGC to be implemented as a party respondent. But while perusing the records, it is seen that it is seen that the amended cost title is not yet. Do you know that you have filed your amended cost title? No.
Lordship, I will have to inquire from my juniors.
Some of the amended cost title is not available in the case record. And accordingly, the learned counsel for the petitioner submitted that she will make an inquiry from the registry. And in the same time, she further submitted that she will also make an inquiry regarding the service of notice on the party respondent uses.
What order was here on?
In view of this, that all matters be taken up. You want to fix it on Tuesday?
Yes, Lordship.
Third.
I will check up. Lordship, in IA number 31, UGC have been implemented as the respondent number 12.
12.
Yes,
It's going to-
in 188, K20.
So the UGC is respond number 12
Yes, in 188.
in
Read petition 188.
180.
Yes.
Now, okay, then you see all this, check all these things and then to submit. So party respondent list on as briefed for, list the matter accordingly on 3/6/2020. If it is steps have not been received, and you can take fresh steps.
Lordship,
I'll
Lordship.
also see the records and just verify.
Yes,
if I
yes, I'll do that. I'll do that. Lordship.
Much obliged.
Obliged, Lordship.
May I please, your lordship? May I please, your lordship?
Yes,
I beg to mention item number 27.
item number
27.
27, yes.
Lordship, my senior has some personal difficulty today, so kindly list this matter on 16 June.
You for the petitioner,
Yes, Lordship.
CGSC is the. you-
Oh, I'm the standing counsel for the respondents, Your Honor. Yes. I'm yet to receive instructions, Your Honor. So,
File your affidavit.
yes.
RMS Swens, the learned counsel appearing for the. You are appearing for Mr. Thuke.
I'm appearing for, on behalf of Ravi Shankar Sharma.
Ravi Shankar Sharma,
Yes.
in item number 27,
Yes, Your Lordship.
appearing on behalf of and this counsel, Mr. Ravi Shankar Sharma. And wait for an adjournment. In the meantime, the learned standing counsel appearing for the respondents also create some accommodation to file their affidavit in opposition. Please remember accordingly how, when you.
On the
we
fixed
have
date,
a-
Your Honor.
16/6.
16.
This the matter accordingly, 16/6.
Lordship, there's interim may continue.
Interim was there, interim be continued. The next date.
May I please, Lordship? Lordship, I'd like to mention item number 38 and 39 on behalf of the learned CGC, Mr. Gauhati.
38 and 39, you are appealing for, learned?
On behalf of Mr. Yangarwati, learned CGC.
Learned seats.
Yes,
For the
for respondent number 6.
For the respond number 6. Learned seats. Treat for an adjournment also. And for the petitioner, you are appealing here.
I'm for the petition.
In both the matters, you are appealing for the
Yes.
petition.
What and all
And comment is also there,
Yes, Your Lordship, for respondent 1 to 4.
1 to 4.
Yes,
So hard as made it, the learned comment advocate appearing for just 1 to 4, state respondent number 1. So you need
2 weeks time. Thank you, sir.
this recording after 2 weeks. Okay,
Much obliged.
I beg your pardon, Lordship. Interim order may be continued in the,
in all the items?
yes, in the
4 to 16.
Lordship.
In item number 4 to 16, interim orders be continued till next. Okay. we'll pass.
Obliged, Lordship.
May I please, Your Lordship? Lordship, I beg to mention item number 18. Lordship, here I'm here to file my affidavit, Lordship, in opposition. So can you grant me 3 weeks time, Lordship?
In item number 18,
18.
here you are for the petitioner.
Lordship.
Same order called the request made by so and so. And let the matter be listed so and so accordingly. You let the matter be listed, you need how many weeks here?
3 weeks, Lordship.
3 weeks time, and I'm going to state respondent to file your affidavit in opposition. List according. Okay.
Lordship, I have a similar prayer for item 24.
Yes, item 24. Here also you have been for the state respondents?
Yes, Lordship.
Do you have any objection here also?
Lordship, I have no objection.
No objection. We do the request made by the learned counsel, so and so. List the matter 3 weeks here also.
3 weeks, 3 weeks,
3 weeks
Lordship.
time to file, enabling the state respondent to file their affidavit in opposition. List according.
Much obliged, Lordship.
Please, Your Lordship, I beg to mention item 25, Your Lordship. Here I'm here to receive instructions. So Your Lordship may kindly let it be listed after 3 weeks, Your Lordship.
Here for the petitioner, you are appealing.
For the petitioner. Lordship is an interim. Can the interim continue?
Interim was there. So you are appealing for the. state
Respondents 1, 2, and 3, Your Lordship.
All are
State.
state respondents?
Oh, yes, Your Lordship.
And what about the private respondent? They have
I
already
have
filed?
respondent number 4.
You have already filed your
No,
affidavit?
Lordship. I will.
Same order. could you? Interim was there?
Yes.
Interim be continued till next date.
Let's
List you want
Obliged.
3 weeks here?
After 3 weeks, Your Lordship.
List according to 3 weeks. And I'm linked the respondents file their affidavit. State respondents and the private respondents file their affidavit.
Obliged, Your Lordship.
Please take. Yes, interim will be continued till next date of list.
May I please, Your Lordship? Lordship, I beg to mention item 33. Lordship,
Yes,
I'm instructed to appear for respondent 3. That is the aggrieved party. And only today we are appearing for the first time.
for the respond number 3.
Yes, Lordship. So, Lordship,
You have filed your
on,
wakalat nama or not yet?
no, Lordship, only on the next occasion, we will be filing our wakalanama as well as affidavit in opposition, Lordship. So kindly give us 4 weeks' time, Lordship.
Otherwise, why it was a fixed matter? How it was fixed matter? You have not appeared there. The matter was fixed otherwise.
We are appearing for the first time, Lordship. Lordship.
My lord, I'm preparing for state respondent number 1 and 2.
State respond number 1.
I'm still
You have
waiting
already
for
filed your-
proper instructions.
You have not get your proper instructions?
Yes, my lord.
You are for the petitioner here?
Yes, Your Lordship.
Wonderful. MS so and so appearing for the petitioner. And also heard. You are Mr.
Kenyang Singh.
So and so the appearing
For
for
respond-
the respond number 3.
My lord, I am for,
And submitted that they will file a wakalat nama and the this affidavit in opposition on the next date of listing. And
LD Sanctum,
LD Sanctum,
additional AG.
additional AG appearing for the state respondent number 1 and 2. List the matters accordingly. You need how many weeks?
4 weeks, Lordship.
This accordingly up to 4 weeks, enabling the state respondents and the private respondents to file their affidavit in opposition.
Your
Is
Lordship,
there any
yes, Your
interim or
Lordship.
interim will continue till next date of?
Much.
Much obliged, Lordship.
Yes, Lordship. Lordship, I beg to mention item 32. 32, in item 32, I have instruction to appear for respondent number 8.
For respondent number 8.
Number 8, Lordship. Other respondents are represented. So
Other respondents are already, state is there, na?
state is there and the union is there, they're represented.
So you are for the appearing on the other respondents from 1 to 7, all the states or?
Yes, Your Lordship.
Lordship,
States.
one is the Union of India.
One is the
Yes.
Union of India. So you are appearing for 1.
No, I'm the for the petitioner.
Oh, sorry, you're for the petitioner.
They know one is appearing on behalf of the Union of India. However,
But Union of India can represent by,
No, Your Lordship, they have a different council, Your Lordship.
notice is completed, Your Honor.
some matter to do, so record to do. 32, item number 32.
Mr. Gauhati, CGC is representing respondent 1.
Yes, that's what I was want to also see. So he has already appeared.
Yes,
Yes, yes,
The last occasion also he has appeared.
yes. So now today the matter was listed in orders.
Comment and
Because-
look at your representing 2, 3, 4, 5, 6 and 7.
Yes, Your Lordship, to the.
Now
second.
8, you have the
8, yes,
instructions to appear.
Yes. I'll be filing my power within 2-3 weeks. And I'll be filing my affidavit also. So kindly grant me at least 3 weeks times.
Otherwise state, you have already filed your
No, Your Lordship,
affidavit.
I mean, also yet to file, Your Lordship, so.
Yet to file.
Yes, Your Lordship, so I may also be given some time, Your Lordship.
Item 32, no? But your
That will know, yeah.
the counsel for the petition. And also heard MS Ina Holina, the learned and government advocate, appearing on behalf of respondent number 2, 3, 4, 5, 6 and 7. And also heard Mr.
Oseko.
Seko, the counsel appearing for the respondent number 8. And as on instructions, he appeared for the respondent number 8. And it is submitted by him that he needs 3 weeks time.
Lordship, 3 weeks time.
To file the affidavit in opposition. And then context, MS so and so, the learned government advocate appearing for the state respondents also submitted that they are yet to file their affidavit in opposition. list the matter accordingly. You all need 3 weeks, only?
3 weeks, Lordship.
List the matter accordingly after 3 weeks, enabling the respondents to file their affidavit in oppositions. Okay.
Much obliged.
May it please your lordship, I beg to mention hearing item 37. Kindly this matter may be listed after a week, 6 months senior is in this post.
Item number 37.
Yes, your lordship.
So you're for the respondent.
Yes, respondent number 3.
Respond number 3. You're for the petitioner.
Yes, your lordship.
For the request. You're for
I'm for the state, for respondent 1 and 2.
hard Kohima, hard so and so. At the request made by the learned counsel for the respondent number 3. Let the matter be accordingly listed. You need, he is indisposed means after 1 week or 2 weeks he will be.
After a week.
After a week, list the matter accordingly after a week. Otherwise, case is ready for hearing. You have already filed your affidavit in opposition, etc. After a week, as already 2 weeks by the list. Okay, we are listing it after. Is there any 3 months day? No. No.
For motion, item number 1.
Your petitioner is on bail under medical ground.
Yes, my lord.
He is already on bail.
No, my lord.
For your
My
prayer,
bail
you have
application.
filed your prayer
Yes, my lord. I'm praying for bail on medical ground.
on medical ground.
Yes, my lord. Here, my lord, my bail
So
application.
he is been arrested under section 21C.
Yes, my lord. 21C.
It's an NDPS matter.
Yes, my lord.
Yes, what is your submission?
My lord, the fact of the case is that the alleged accused was arrested on 20 March 2025 from Kampok P, Manipur, in connection with.
20 March.
Uh,
20
yes, my lord.
03.
Yes, my lord. 20 March. From Kampok P, police station, in connection with Stemenu PS case number 003 of 2024, dated 12/2/2024, where initially first 2 accused, namely Rajesh Singh of Golagat and Ananta Saikya of Golagat, Assam, were first arrested. And on further investigation on suspicion, the petitioner was arrested from Kampok P on 20 March 2025. And my lord, well, under custody, the petitioner have moved 2 bail applications before a special court NDPS Kohima on medical ground. But unfortunately, his bail was rejected by the special court NDPS Kohima on the condition that on the first rejection, on the ground that the medical doctor have not referred him for outside treatment, and that well, during the time of production, the accused himself has stated that he's okay, his health is okay. On that ground, the first bail application was rejected. And on second ground also, though the medical officer have referred to him for cerebral palsy test, which is a very serious illness, and for his brain CT test, CT scan, but the testing facility was not available in the Naga Hospital Authority, which is a district hospital in Kohima, so the test could not be carried out, which the special court and DPS have clearly acknowledged that there was no facility in the state hospital, and that the concerned medical officer have not referred him for outside treatment. But my lord, normally in NDPS cases, any medical officer, they don't refer the under trial prisoner for outside treatment because they have fear of being summoned or examined by the court. That is a normal practice. Most cases, the medical. In most cases, for the under trial prisoner, especially under NDPS offense, the medical doctor, they don't refer such under trial prisoners for outside treatment because they fear that they will be examined or summoned by the court.
Examine or summoned by the court.
Yes, yes. To verify their statement, their reference of the particular accused for outside treatment to avail treatment from outside the state. So on that ground, my bail application in the special court NDPS was rejected.
The jail authority and the doctors, they are under that fear that they might be called by the court and they may be examined.
Yes, my lord, yes, my lord.
Then
Not the jail doctor, but the doctor in the district hospital.
who
Yes,
referred.
yes. Yeah, though the situation is serious, they don't normally do that. So on that ground, since I was not referred by the medical officer, though the medical officer have himself recommended that I undertake cerebral palsy test and CT brain scan, which is not available in the district hospital. And my lord, I have clearly stated to the medical officer that I consume all those SP drugs and alcohol and other illegal substance drugs. So because of that also
You
I have
say consumer.
yeah, I also say consumer, but since it is under a commercial quantity, I could not avail the provision of section 60.
Is there any withdrawal symptoms?
Yeah, withdrawal symptoms is there and memory loss and fatigue, headache. I have all the problem. I even have a problem with the medical officer have even referred me to to go for urology test, but I could not avail that treatment also in a hospital since there's just a specialized treatment available. Well, and moreover, prior page 27A, well, before my arrest, well, I was under
Page.
going 27A.
27.
Yeah, before my arrest, I was undertaking treatment from primary health center, Gampazo. The concerned medical officer have also referred me to seek a psychiatrist doctor treatment, but that also because of lack of finance, I could not avail the treatment. And unfortunately, after that, I was arrested. And on page 27, because of my heart problem also suspected, I was referred to cardiologist. But unfortunately, before I could arrange all the finance, I was arrested. And my lord, my humble prayer is that since life, health is, I have the right to live with a good health and dignity. And Article 21 clearly says a person's right have to be protected according to the procedure established by law. So, my lord, my prayer on medical ground may be considered because after a permanent damage is done to my body, it cannot be recovered. Even I spend a lot of money.
So how you develop your cerebral palsy? Because it is generally what is a genetic problem and from the childhood or from the one
Because of my
develops a
habit.
cerebral
Yes,
palsy.
because
so how
of
you subsequently develop that and as per your medical documents
Yes,
you have
yes.
submitted as an outdoor patient you have some
Yeah.
but there is no nothing at all that you are suffering from any cerebral palsy. And yes, obviously the cardiologist was referred by doctors and all.
I'll come to that
They have
more.
chronic liver disease also. That was there only.
The doctor who has examined me have suspicion that
Suspected.
I may have this. I may have this.
Because there are some symptoms in
cerebral
cerebral
palsy.
palsy.
Yes.
It's not a case that you are
But the
suddenly you
prisoner
develop
is
this now.
constantly moving and he have no control over his body muscle. And that was also even acknowledged by the session special judge himself. In discussion with the jailer on his health, the jailer himself have told me that even the special judge have asked him whether he has such issues or not. But since the petitioner himself is not very educated, though he's educated, but since he's mentally is not that clear now, so he cannot.
So basically on the medical ground, you're seeking bail here.
Yes, mother, yes, mother. He's constantly moving. He's talking to himself, even in court at the time of production. And this was even acknowledged by the special judge. But since unfortunately the concerned medical doctor have not referred me to seek outside treatment. So on that ground, my bail application was rejected. But in the near future, we never know what the problem you face again. So before permanent damage is done to his health, I humbly pray that his medical ground, bail or medical ground, maybe look into at the time of at the time disposing of the consent bill application.
Yes.
Please, Your Lady, since the rejections of the previous two bail application, Your Lordship, there is no change in circumstances, Your Lordship. In the earlier bail application also, the petitioner has took a ground of medical. Here also same. So unless there is change in circumstances, Your Lordship, no interference is warranted, Your Lordship.
Have you, these are the reports from some reports you have annexed here.
Yes, my lord.
That is from page 27, then up to say 31. There are
Yes,
some
on page
tests and
32.
some medical.
On page 32, I was referred. On page 32, I was referred cerebral palsy test and CT brain scan. But since there is no testing facility, he cannot go further
So we
treatment.
can do one thing, let the press medical report be submitted by the jail authority at what kind of problem he is facing. Obviously, you have submitted that in medical grounds, two petitions were earlier moved. Those were rejected by the court.
Lordship.
And obviously, no change of circumstance in a case, in the sense that
Your Lord,
obviously he is suffering, that is his submission, that is on
That is
purely on
his
medical
submission.
ground. But we don't have any latest report from the jail authority till now.
Yes, my lord.
So we can at best call for a authority, and if there any treatment is providing by the jail authority, that has to be seen. Otherwise, he is suffering, he may
Your
have some-
Lady,
Yes.
the court below has already given a direction. If Your Lady may kindly come to page 22.
22.
22. Para 5. Para 5.
Yes.
I have considered the submission of both the parties, perused the FIR charge sheet and the accompanying documents placed before me. This court has gone through the case diary. On going through the same, there is prima facie incriminating materials against the accused. It appears from the record that after the arrest of the accused on the strength of WA, supplementary charge sheet is to be filed by the IO, for which charge is yet to be framed against the accused. On carefully going through the medical grounds of the accused, it shows that the accused has been taken for medical treatment at Naga Hospital Authority Kohima on 2nd of May 2025 and on 7/5/2025 for his complaints in respect of his health issues, and accordingly medicines have been prescribed for his ailments. With regard to the submission of the learned counsel that the CT scan brain of the accused could not be done due to non-availability of facilities at the hospital, perusal of the treatment report shows that he has been examined by the psychiatrist on 7/5/25 and has advised for review and report. The medical documents annexed to the petition nowhere shows referring the accused for higher management or treatment outside the state. In view of the aforesaid, this court is not inclined to release the accused on bail on medical ground at this stage. However, the jail authorities, Your Lordship, is hereby directed to provide proper medical treatment to the accused if he reports to be sick, Your Lordship. So, Your Lordship, unless order is already there, so unless there is change in circumstances, Your Lordship, whether interference can be
Yes, in that.
allowed.
My lord, I may be allowed to counter. My lord, the special judge herself have acknowledged that the CT scan brain of the accused could not be done due to non-availability of facilities. Herself acknowledged. And to give him proper medical treatment to the accused if reported to be sick. But if there is no proper facility in the district hospital from where the accused will avail the proper medical treatment, though the accused is having a serious health issues and he have lost weight.
The question is that it is your submission. Your submitted with regard to submission of learned counsel that the CT scan brain of the accused could not be done due to non-availability. That is your submission. That is not the case that the jail authority has also, asked that the CT scan is necessary and all. These are not prescribed or referred by any doctor. These are your submission that a CT scan is also required. But in that case, one psychiatrist has already consulted with the alien and there was a report. That is the observation. Anyway, we definitely will call for a medical report as you have submitted. Is there any problem with the accused?
Yes, my
At
lord.
best, we can call for a report.
Yeah, yes, my lord.
Because as Ms. Mary has submitted that there is no such change of circumstances as the order passed by the learned special judge, and before this petition, there is no such changes of circumstances. Or we don't know what is the stage of the, the petitioner, how he is suffering, or that is not before us. So at best we can call for, otherwise we don't have anything to say, because it's a case of moreover, the part of the investigation is still under process, because charge sheet is yet to be supplementary, charge sheet is yet to be filed, if there is any case against this petition. Because he got arrested subsequently, I think. He got arrested subsequently by
Yes,
this.
yes, yes.
That is also there.
Yes, my lord, on page 32, he was referred for cerebral palsy and CT scan brain on page 32, Dr. writes clearly, and for review and report. But for review and report after the test scan, but that could not be, review and report could not be carried out because there was no facility, though the accused had a serious
In
problem.
fact, Kohima, there is no facility at all.
In the
Kohima-
Naga hospital at present, there is no facility for that. Yes.
Strange.
Yeah, so it is a very serious health issues, but because of lack of facility, review and report could not be carried out at the time of filing the application. Yeah, so even if report to be sick, since there's no test facility, you just remain like that. So there's no question of tense circumstances. As a matter of fact, because review and report could not be carried out because there was no testing facility, so he could not avail further treatment. So he's still suffering, my lord. So yeah, that facts you can be taken into
You are
consideration.
Mr.
I'm Pakrin Chow, my lord.
Bakrin the counsel for the petitioner, and also heard MS made the learned PP appearing on behalf of state respondent. And this is an application under section so and so in connection with so and so. It is submitted by Mr. Bakrin Chow, the counsel for the petition, that the present application, the present petitioner got arrested in connection with this case on 20/03/2025, only on suspicion after arrest of two other co-accused persons. However, he filed two applications for bail was preferred before the learned special judge and the PS. Those were solely on the medical ground, that those were rejected by the learned special judge so and so. Next para, he submitted that presently the accused petitioner is suffering from cerebral palsy, and for which he has already been referred for CT scan, but which could not be done due to non-availability of the facility in the state key. It comes both ways in
Naga Hospital.
Naga
Authority.
Hospital.
Yeah.
Naga Hospital.
Kohima.
Kohima. And accordingly, he submitted that for his treatment outside the jail premises, the bail is he paid for accordingly on the medical ground. The petitioner has paid to release him on bail so that he can take the treatment outside jail. Next, in that context, MS Mary, the learned PP has submitted that there is no change of circumstances in the present petition and the two earlier petition were rejected by the learned special judge, which were also filed on the medical ground. In the order passed by the learned special judge so and so, it has already been discussed in detail regarding his treatment, provided to the petitioner and the medicines which had been prescribed to the petitioner. Accordingly, she submitted that there is no new ground to consider the present bail application, which were earlier rejected by the learned special judge and DPS. So and so, the area is from learned special judge and DPS, which
Kohima.
district? Kohima.
Gemini.
Next. The hearing the submission made by learning council for good sense, it is seen that the earlier two bail applications were also rejected by the learned special judge and DPS Kohima, which were also filed on the same medical ground. However, it is from the medical documents filed by by the counsel for the petitioner, it is seen that he was also referred for CT scan as he is complaining from having the symptoms of cerebral palsy. But it is seen from the order passed by the learned special judge that the patient was also the psychiatrist had also consulted with the patient, and the treatment was accordingly provided to him. Next, Pura, in view of this and considering the submission made by learned counsel for both sides, later detailed medical report be called for from the jail authority, including the report as to what kind of medical treatment is providing to the present petition at this stage.
Also, your lordship, a scanned copy of the CD may be called.
Yes, scan copy of the case diary also be called for. This jail authority be informed accordingly. List the matter. You need
after a week.
After a week. List accordingly after a week.
For motion, item number 2.
One IA is there.
Yes, my lord, the IA is filed in connection with implementing the current deputy commissioner of the Nebuto. At the time of filing this contempt petition, the previous deputy commissioner, namely Sri Rahul Banantas Mali, was the deputy commissioner to Nebuto. But after filing the contempt petition, he was transferred to other department, and now Mr. Sri Dharamraj is transferred as a deputy commissioner to Nebuto. So since there's a change of guard, I've paid the honorable court to allow me to file an IA to implement the incumbent deputy commissioner, and this honorable court by order 5/5/2025 have allowed me to file an IA for implementing the present deputy commissioner.
So he will be implemented as a respondent number?
3.
3. Respondent number 3 at present.
Yes,
Earlier, how many respondents were there? 2 respondents?
in contempt petition, 3 respondent.
So in place of earlier 3, and now
Yes.
he will be as a 3.
Yes, ma'am. I think so.
Do you have any?
No.
The earlier order was passed on which date?
On May 5, madam.
May 5.
Yes, ma'am.
Heard Mr. Pakinri Chabu, the learned counsel for the petition, and also heard
My lord, I may be allowed to rectify my submission. The present DC may be implemented as 4.
that's what I'm
Previous as
asking.
3.
So heard Mr. Sen, so you are appealing for respondent number?
Respondent 2.
Respondent number 2. Full stop. It is submitted by Mr. Pakincharu, the counsel for the petitioner, that in pursuant to order dated 5/5/2025, the present I has been filed for implementing the new incumbent, the new DC, as a party respondent number 4, as the earlier deputy commissioner has already got transferred, and accordingly it is paid that the new deputy commissioner may be implemented as a respondent number, to which the learned counsel appealing for the respondent number 2 raised no objection. Accordingly, the present IA stands allowed with the direction to the respondent to file the amended cost title, including the new DC. Mr. What is his name?
Dharamraj.
You have named here, no?
Yes.
Doctor
Yes.
Dharam?
Respondent number Dharamraj, page 2.
Dharam Raj.
Yes, Dharamraj.
Dharam Raj as a respondent, party respondent number 4. Cost title so and so, and also will also take steps for issuance of notice to the newly implemented respondent number 4. With your above observation, the IA stands disposed of. Perhaps no itu dano, COP dano. Next itu dano, in view of order passed in IS civil number 74 of 2025. The petitioner is hereby asked to file the amended cost title as well as to take steps on this to register AD as usual process, list accordingly. After 4 weeks we'll do. 4 weeks you
Yes,
read,
ma'am.
list accordingly after 4 weeks. Okay.
Obliged.
For admission, item number 3.
Yeah, Mr. Lordship.
Yes.
Lordship, this is a condemned petition. This petition is filed for non-compliance of this honorable court's order dated 19/5/2022. Lordship, may kindly come to page 19 of the contempt petition,
Page number
page 19,
19.
19. Lordship Gauhati. Matter pertains to non-payment of minimum base skill due to taxpayer employees. And Lordship, this honorable court, on consideration of the principle laid down in Chakchit Singh case, Lordship, bust this order, page 21, Lordship, the operative part. After hearing the learned paragraph 4, Lordship, after hearing the learned counsel and after perusal of the reports, it appears that the department concerned and the other department under the government of Nagaland had granted scale of pay to the work charge employees who have served for many years, either after direction to do so were issued by this court or after considering the representation of the employees. Further, it is clear from the impugned letter rejecting the request of the petitioner that the engineer-in-chief have taken the decision all by himself and without consulting the government, which he ought to have done as in the case of other employees. Further, it appears that the engineer-in-chief is oblivious of the principle of law, settled in case like State of Punjab versus Chakchit Singh case, reported in so, wherein it has been settled that work charge employees are entitled to equal be provided they are discharging the same duties as regular employees. In view of what has been stated above, this court is of the view that the impugned letter is of the engineer-in-chief is liable to be citizen quash. Accordingly, it is quashed and set aside. And in consequence, the respondent number 2 and 3 are once again directed to consider the case of the petitioner in the light of the facts and circumstances and the principle of law stated above. The same should be done within a period of 2 months from the date of receipt of a copy of this order. Nevertheless, but it is made clear the petitioner shall have the liberty to approach this court in case he is not satisfied with the order passed on the matter by the authorities concerned. So direction was to consider my case for payment of minimum base scale. Lordship, during the pendency of this contempt petition, Lordship, the state government came up with a notification office memorandum, Lordship, which is furnished to your Lordship by my learned friend, Lordship. That is office memorandum dated 5/3/2025. 5/3/2025.
Yes.
Conversion of wages of work charge and casual employees to scale B asked for revision on pay scale ROV 2015. Under the recommendation of the Nagaland Work Charge and Casual Employees Commission and pursuance of the cabinet decision convened by number so dated 25th April 2025, all work charge and casual employees and all the departments whose names have duly verified by the district level verification committee and registered in VIMS receiving fixed B shall be granted scale of B as per revision of B 2015 with effect from 1/4/2025. This office memorandum covers my case also, Lordship. However, in spite of this office memorandum, Lordship, till date, the government have not taken any initiative to grant the minimum wage scale. Therefore, issuance of this office memorandum is one thing, and complaints of the order passed by this honorable court is another. Therefore, Lordship, till date, the respondent authorities have not complied with the direction of the
Lordship say, the order passed by this honorable court is very clear to consider his case. There is not a direction to directly give him the minimum scale of pay, but to consider his case for payment of minimum scale of pay, based on which the government we have brought out the policy 5/3/2025, wherein we have stated that the petitioner is to be granted scale of pay with effect from 1/4/2025. So the direction or of this honorable court is fully complied. If at all the petitioner is aggrieved with this order, he can always file
I'm not
another
agreeing.
suit.
I'm satisfied with the order.
Otherwise,
I'm satisfied. Well, Lordship, it's
if
fine.
he is
But
satisfied,
they-
then I pray that
they
the
have not
contempt may be
applied to it.
closed.
You're saying that, okay, this order is here, the
Yes.
government side and the,
Yes.
where maybe your case
That's
may
fine.
be covered. But the question is that till that you have said that they have no steps has been taken by the
Yes,
government.
that is the case.
So
We have been
you have
taking
take-
step,
take step-
because this order is in 5 March 2025. And by another office memorandum, 5/5/2025, we have brought out as to how the fixation of the pay is to be. The
Okay, then
finance
next week
department.
you can file these things, otherwise we may fix it.
Otherwise,
Yes. Yes.
my ladyship, everything is complied with. There's nothing point
No,
of keeping petty
it's not
because
subject.
it's between the court and the contender. And if we see, we have brought out the policy
fine.
where
You
the
need to point
petitioner
out.
is to be given
It's fine. You need to point out.
From 1/4.
1/4/2025. If at all we have not paid, then he would have another course of action,
No.
but not in
Why
this
we go
contempt.
for another cause of action? Let him do one thing. By the time, if 5/5 notification is also there, where all the names and things are there. So let us bring this notification
Then if that
before
is the
us.
case, then in order to make it
Because he is not in a position to say as to whether there is any proper or total compliance is still there.
no. The content of the policy is very
Yes,
clear that he is
obviously,
going
yes.
to get. So if that is the case, then let him wait for some few months so that
Few
he
months?
can.
Why
Yes,
for few months?
because it is not only pertaining to one individual.
Yes,
It's
obviously, that is
so
that.
many in terms of thousands and thousands of employees. So my leadership, then if that is the
In
case,
that
let the
case,
contempt be maintained.
if you allow some time, suppose, in that case, by the time if your petitioners, you get your salary and all everything, then it will be okay. Otherwise, if
Yes,
you
Lordship.
withdraw this one at this stage, if we don't know subsequently why for next cause of action, you do wait, isn't it? So,
Otherwise, in similar cases, also this honorable court, based on this government policy, has closed the contempt, because contempt will be the willful disobedience. There is no
obviously,
willful
obviously, that is there,
disobedience.
that is there. Yes, what do you want to say?
Lordship,
Should I close this on the
No.
basis of this one?
The government have already issued the office memorandum, fine, Lordship. I'm happy with that. But then it is the duty of the respondent to comply with the court's order, granting me the minimum base skill, Lordship. That is
No,
not
that's
been
what they are going to do, in fact.
Same submission was made at the earlier occasion, Lordship, may kindly peruse the last order. 12/18/2025. This honorable court have not
Because that point of time, we have not brought out
accepted
this.
such submission, Lordship.
We have not brought out the policy. That point of time, it was placed before the cabinet for its approval. Only by 5th of
No,
March
that is on
only,
the,
we brought
on
the
that
policy.
occasion, on the 18/2.
Yes.
It was her submission that most probably the additional AG has submitted that there are certain amendments and there's already the government has taken up some decision. But,
Yes.
The way of memorandum, it has come out only in the month of
March, yes.
That is
I'm happy with the memorandum, Lordship. But then the respondent has to comply with the court's order, granting me the minimum base skill.
Then,
which is
then
yet-
can we, can it
which
be
is yet to
listed?
be done, Lord, which is yet to be done.
Now see, Ms. Sukri, she is submitting that it may take some time because it
Let
is
the-
not
let-
only the, not
Let
only
them
the
take
case
time,
of.
Lordship,
Okay,
to comply with the order. 2 weeks, 3 weeks, Lordship.
okay, 3 weeks then.
I'm not
Otherwise, you can
insisting-
close the matter here.
I'm not saying this honorable court to
Otherwise,
punish the
they can
condemner, but to
close.
comply the order.
You are Mr.
What is Jamil?
Jamil, the counsel for the petition, also heard MS P. Chokri, the learned additional AG, appearing for the state respondent. It is submitted by her that already the comment memorandum is, their office memorandum is already there, dated 5/3/2025, wherein the case of the present petitioner also covers. And accordingly, this is submitted that the matter will be closed on the basis of the office memorandum, which was issued on 5/3/2025. In that context, Mr. Jamil submitted that though the memorandum was issued by the state government, but till that there is no proper compliance of the order, and accordingly he submitted that to order full stop in view of this. Let the matter be listed accordingly after 3 weeks, so that the government can comply with the order of the court as well as the office memorandum. List accordingly after 3 weeks.
Obviously.
For admission, item number 17.
17. Yes, you are paying time. I mean, it was quick, but till now also the petitioner side is not appearing now.
Lordship, it seems that like my colleague confirmed me that like the matter is already, I mean, like she has already filed an affidavit. That is the only instruction. I don't know regarding the petitioner, Your Lordship.
No, that's what
Whether
I'm
he's
saying.
making
You have
notes.
already in the morning hours also, you have
Yes.
submitted that
Yes.
there is a instruction. So as per your instructions, your colleague has already filed the affidavit. Item number 17, none appears on call for the petitioners. However, it is submitted, however, you are MS.
Livika, Your Lordship.
Livika appearing on behalf of
AIME.
AIME, appearing on behalf of AIME for the respondent submitted that. Respond number, is there any respond number?
For the state respondent, no,
For the
the
state
other.
respondent, for the state respondent. And he had already filed their affidavit in opposition. List the matter accordingly after 3 weeks we are listed.
For admission, item number 26.
May I please the Lordship? Lordship, here I'm
For the respondent again,
Lordship, I'm for respondent number 1 to 6, Lordship.
1 to 6.
Lordship. Lordship, I have received the parawise instruction from the Deputy Commissioner Chumukrima, Lordship. However, I'm yet to receive the instruction from the respondent number 2. That is the Home Commissioner, Lordship. So if Lordship may please to grant another 3 weeks time, Lordship.
Okay, you are for the petitioner.
Yes, Lordship. Lordship, in fact, this is the second round of litigation. Lordship, the fact involved has already been dealt in the first read petition. Now, the petitioners were initially agreed by the action of the Deputy Commissioner is suspending the Village Council, because there's no provision under the Village Council Act by the Deputy Commissioner to suspend the Village Council. So that was questioned. Now, immediately during the pendency, when the issue was brought up by the court, immediately the government has dissolved the Village Council.
Dissolved.
Dissolved.
It is.
So in fact, the instructions are all there as per the last read petition, Lordship.
Lordship, as far as from the approval of the Home Commissioner, Lordship, the Deputy Commissioner Chumukrima has suspended dissolved the council,
Dissolved
Lordship. So I need the instruction from the respondent number 2, that is the Home Commissioner, Lordship, as to how the approval has been given, Lordship.
Lordship, we are in the 4th year of our tenure, because the tenure is for 5 years. We are in the 4th year, and we have been suspended from after 9 months of we taking over as a village council. They have been delaying all this while, Lordship.
So by the time of
26
the disposal of the WPC,
our tenure will go over, Lordship. And the village is functioning without a council, village council. Lordship, there's an urgency. And in fact, by the last read petition also, Lordship, they have taken enough time in delaying the matter. Lordship, had it not been a tenure post, I have no issue, Lordship, let it go for 10 years. But my tenure is still up to 2026. It'll get over by next year, March.
Lordship, I'm allowed to
Lordship,
accept
in
Now
to
see, the
get my
question is that
instruction,
you have
Lordship.
already got the parawise instruction
From the deputy
from the
commissioner.
deputy
However,
commissioner, but the response number 2, you're still waiting. But the
Lordship.
question is that he is rightly submitted. Now this is the 4th year, suppose, and if the till now there is no village council in fact.
Lordship.
Under what authority, under under what instructions the village council was been dissolved. That is to be issue to be decided or discussed. But the question is that till now there is no village council. The entire village is as per he submitted.
Lordship, there is a
So
caretaker.
as per you, when we will be able to.
I'm allowed 3 weeks time, Lordship, to get my necessary.
Lordship, as per the report submitted by the Deputy Commissioner, the Home Commissioner has acted on it.
Lordship.
And the Deputy Commissioner has made a report with regard to allegation even prior to we were appointed as VCM, 2017-18. We were appointed in 2021. Basing on 2017-18 report, there was some misappropriation. We have been dissolved. Lordship, in fact, the Deputy Commissioner report is the basis how the respondent number 2 has dissolved our council. So what's there for the Home Commissioner to say, Lordship? Home Commissioner has acted on the.
Now he is saying that this is the under the approval of the Home
Lordship,
Commissioner.
it is the
That's
approval of
his
the Home
submission
Commissioner.
anyway. Okay, then.
But report is from the Deputy Commissioner, and he's got the powers from the Deputy Commissioner. Let it be, please, Lordship. Because the only question here, Lordship, to be decided by this court is.
So if you have got the parawise comment from the Deputy Commissioner, in fact.
Lordship.
So in that regard also you have not filed your affidavit in opposition till.
Lordship, Lordship, I'm allowed 2 weeks time, then I will file my affidavit in opposition on
2 weeks,
on behalf of
2
the.
weeks again. Maybe they are waiting for my tenure to get over, Lordship. Then ultimately next year, March, my petition becomes infructuous.
Lordship, 2 weeks time to file my affidavit in opposition on behalf.
And if no, Lordship, okay, 3 weeks, but if no affidavit is filed, Lordship, basing on the record, then let the matter be decided, Lordship, because I've placed everything on record. Everything is on record, Lordship.
Lordship.
Hard Mr. You are Mr.
N. Mozoi.
N. Mozoi, the counsel for the petitioner, and also hard Mr.
Bijomo.
Bijomo, the learned, you are comment advocate.
Lordship.
Learned comment advocate appearing for the respondents, number 1 to 6. He submitted that he had already received the parawise comment from the Deputy Commissioner. However, he needs 3 weeks time to file their written, to file their affidavit in opposition.
Lordship.
In the meantime, he further submitted that he is yet to receive the parawise comment from the respondent number 2, who is the Home Commissioner,
Lordship.
under whose approval the village council was dissolved.
Lordship.
Considering the submission made by the council for both sides, let the matter be listed accordingly up to 3 weeks, directing the respondent to file their affidavit in opposition on or before the next date of list according. Okay.
If my submission may be recorded, Lordship, that if no affidavit is filed on that day, Lordship, the matter may be heard on merit, Lordship.
Okay,
Because.
can be recorded. Okay, we
Lordship,
are not
this
recording
is-
it. Okay.
Nice.
Item
Obliged.
26.
For orders, item number 28.
Yes.
Yes, Lordship. Lordship, I'm for the sole respondent here.
For the sole respondent.
Yes, Lordship. Lordship, in the last occasion, the petitioner has sought time stating that the senior has some personal difficulty. However, Your Lordship, along with the civil revision, the petitioner have filed an IA for condemnation of delay, to which the court
That
has
has
allowed.
already been disposed or not?
No, no.
I is also there.
IA is there. Your
But
Lordship,
why
IA
I
was
is not
filed.
listed today? Yeah.
Lordship, IA was withdrawn with liberty to file afresh. However, till date, they haven't filed the IA. The first
So
IA was
till now,
filed.
this civil revision petition cannot be admitted. I
Yes,
think.
yes, Lordship. IA was filed in 2023 along with the civil revision. However,
That
the
I was
petitioner,
subsequently withdrawn.
that was
for.
that was
this.
withdrawn, and
No,
then
no,
they
it was
filed
for
the
the condemnation.
yes, Lordship.
Oh.
That was withdrawn and a recast was filed. However, that was also withdrawn, and by the court order dated 15/4/2024, the petitioner was given liberty to file afresh the IA for condemnation. However, till date, they haven't filed. So it is my prayer that it's clear indication that they are not interested in pursuing the case. So I pray that the matter be dismissed.
Let us give one more chance. Heard, no, the non-appears on call for a petition. Heard MS, UMS,
Rovi Meno.
Rovi Meno, the counsel for the petitioner, responded.
Respond.
And it is submitted by her that the present revision petition was supported with an interlocutory application for condonation of delay. But subsequently, that IA has already been withdrawn and we delivered to file a fresh interlocutory application for condonation of delay. But till that, no fresh interlocutory application has been filed. By the
Your Lordship, recast was already filed. The amended IA was already filed. However, that was also withdrawn.
এটা মাজত ক'ত লিখি দিয়ক submitted that তাৰ মাজতে লিখিব that one the amended amended interlocutory application was also filed, but that was subsequently withdrawn. তাৰ আগত হ'ব না এইটো, but till date এতিয়ালৈকে file কৰা নাই, and accordingly she submitted that the petitioner is not interested to proceed with the case, and matter may be closed accordingly. For the ends of justice, let one meeting be given to the petitioner side, list accordingly, list the matter accordingly after. Okay.
Lordship. Lordship.
For orders, item number 31.
Yes, 31.
Lordship.
So this is revision is filed by state only.
Lordship.
So have you taken state for the other side?
Lordship, I have taken the step on 24/3/2025 to register AD, Lordship.
23?
24/3.
Yes.
2025, Lordship. I have taken
No, this
step
issue
to
the
register
control
AD.
responded by state. Fine, true. From the tracking report, it is indicates that delivery was confirmed. But service is still awaited. Let the service be awaited till next date.
Lordship.
And if it is not there, then effectively will go.
Lordship.
Why state has to file this revision petition against? any-
Lordship, we are excelling the order passed by the learned CJ in Kohima, Lordship. Order dated 3/10/2024,
What kind of order was
Lordship.
there?
Lordship, by discharging the liability, Lordship, and against that order, we are excelling. Lordship.
Heard Mr. B. Jamudi, learned government advocate appearing for the petitioner. From the office note, it is seen that though the delivery is confirmed as from the tracking report, but service is still awaited for the respondent, the sole respondent. Let the service be awaited till next date of listing. List accordingly after 2 weeks.
Lordship.
List accordingly after 2 weeks.
Hello.
For hearing, item numbers 34 and 35.
Please, Your Lordship. Your Lordship, here, the petitioner prayer is that is for granting of minimum scale of pay. So as far as that is concerned, Your Lordship, the government has already brought out a policy, Your Lordship. So the case.
Office memorandum.
Yes, Your Lordship, yes, Your
The
Lordship.
last in other 2 matters.
Yes, Your Lordship. So
So as per you, your petitioner will also be covered with that said memorandum.
Yes, Your Lordship.
But in other case, what was his submission? Some most probably heard also, we heard also. Though there was an office memorandum, the compliance was total compliance or proper compliance was not there till now. So they sought for some more time for the compliance. So in that regard, you want to submit that the matter may be closed on the basis of that memorandum, or you want any date for compliance? Because on the last occasion, last day, I mean, the other case, we have given 3 weeks time so that the government can comply with the, or your petitioner can be covered up with that compliance report. So
I
what
may
do you want to say?
I may be considered as per this memorandum, Your Lordship.
Ah.
A time frame may be given and the matter can be closed, Your
Your,
Lordship.
Your Lordship, it's going in a bulk. So Your Lordship, automatically,
That
Your
was
Lordship.
also submitted by MS Sukri, the council.
Yes,
the
Your
state
Lordship.
Council,
And
but
we have on 2, 3 occasions, our honorable judges was also like, without giving a time frame, Your Lordship, to be considered in light of this, because
we are
there is a
not going-
condition
We are not
here.
going to give you any time frame.
Yes, Your Lordship.
Now, what she submitted in the last matter, that on 5/5/2025, your date is
It-
5/3.
Yeah, 5, 3, it will
Yes,
start from
5/3
1,
is
4.
Office 5/3.
Yes.
So now she is saying, submitted, that on 5/5/2025 also there is another thing is there, wherein all the names of all the beneficiary or whatever were brought in the
Mm.
record.
Mm.
So that was not before us. She could not file also.
Mm.
So why don't you file that one, so that his petition's name maybe complies maybe later on also, because there are several, I mean, thousands, more than thousands also maybe there. So that's why we, in the last time, we have given 3 weeks time. Because now question is that, suppose on the basis of this memorandum, we may close the matter, and their petitioner's case may also be covered with that petition, your memorandum. But if suppose in case, if any compliance is not there, suppose, so was submission that new cause of action may arise, and then again another WPC or COP may file. But that I think that should not be, I think. So we can wait for at least 3 weeks in that case before closing the matter.
That is up to the court. However, Your Lordship, as
No,
per
no,
this.
what your submission, just tell me, because I'm submitting on behalf of this submission made by in earlier case. That's what
If we
I'm
are
saying.
maintaining a list,
Your Lordship, now the case of the petition is before the court. So if this gets disposed, maybe they will have to get their name included in the list also. So that, Your Lordship, the thing is that we want to consider her case also in light of this.
If you say
So
that
it's up to
their
the.
name is not be included in this case, then it would be very.
That's why, Your Lordship, it's up to the petitioner, Your Lordship.
Yes, what do you
For
want
me,
to
Your
submit?
Lordship, to come, as per this, it can be disposed
if
of.
they comply as per this, if my case is considered as per this memorandum, then I have no problem, Your Lordship. However, whether there is a list maintained by the government or
No,
not.
that way you cannot say at this stage.
Yeah.
Do one thing, let it be after 3 weeks only, because closing is okay, but sometimes some way, suppose your name is not there. In that case, I don't know. That's why I'm saying that in that case, if your name is there, the compliance is there, then it can be disposed of. Okay? Because if suppose anyhow your name is not there and all, then again, the matter may be closed. There may be some kind of thing. That's why I'm saying, let it be after 3 weeks only, as memorandum is already there, isn't it? Same liquor. You are MS?
Esther, Your Lordship.
As Deputy Counsel for the petition, both the matters, and also heard MS, so and so, the learned government advocate, appearing for the state respondents. And it is submitted by learned government advocate that there is an office memorandum issued on 5/3/2025, which will also cover the matter of the petitioners. And according this is submitted, the matter may be closed on the on the basis of the office memorandum dated 5/3/2020. However, considering this submission, we file an counsel for both sides and other aspects of the case, let the matter be listed accordingly after 3 weeks, so that there may be proper compliance to that regard. List according after 3 weeks.
For hearing, item number 36.
My lord. The petitioner is page 3, my first statement.
Page 3.
Page 3 of the petition.
Page 3 of your
Read petition. Page 3, para 1. The person before your lordship. It's from Parkland district, Cape which is a declared backward tribe, Sanctum tribe. It's a officially declared backward tribe of Nagaland, apart from being a scheduled tribe.
Type 1 tribe.
Scheduled tribe, that is all Nagas are scheduled tribe people, tribal.
Yes, yes, that is.
Next is, my lord, there is a declared backward tribe of Nagaland. In this, the petitioner who belongs to Sanctum tribe,
Petitioner belongs to Sanctum tribe.
my lord, which is a declared backward tribe in the state of Nagaland. He attended up to class 3 standard.
Now, why they're considered to be back one, you are saying?
My lord, educationally and economically, they are backward among the Nagas.
So Sanctum tribe is backward.
Yes, there are some 4 tribes. There are some backward tribe among the Nagas. Over and above, we read up to class 3. That
Your
is,
petitioner read up to class 3.
my lord. Then, my lord, by annexure 1. Annexure 1. This is service shade.
Annexure 1 in which page?
Page 16.
1-6.
Yes, my lord. Page 21 will be relevant. I have the type copy, it page 21A. This is the service shade, the record of service. In having been declared medically fit by RMO of this unit, hospital such and such, petitioner is temporarily enlisted as recruit constable with effect from 26/4/76 or noon in the scale of such and such, plus all other allowances as admissible under the rule from time to time.
Under which queue? What category he was appointed?
21A is the type copy.
No, what was his service?
Constable.
Constable? Okay.
Yes.
Okay.
In Nagaland Police. This is first.
He was appointed on?
With effect from 26/4/76 or noon. As recruit constable, recruit, RC, they call it RC, recruit constable. That is Commandant First NAP Battalion, Chumukutima, Nagaland. First battalion is the police training center, my lord. Then page 23, that is my para 2.1. That by officer in such, dated 79, the petitioner
Para
was
23. Para 23.
para 2.1, page 4 after the That by office order number such and such, the petitioner was released from first NAB ATM COI company with effect from 7/11/1979 forenoon to join his permanent place of posting at 3rd NEP Battalion, Tuinsang, Nagaland. That is 3rd Battalion is stationed in Tuinsang till today. The petitioner reported as such and such and was allotted regimental number. Earlier it was a recruit number.
He was the sufficient. Okay, yes, 2.1 then.
His regimental number is 32-23-7.
Regimental number.
Regimental number, man. Yes.
Yes.
That is it, page 23 of the service sheet.
23.
Yes. In the interest of public service, he is transferred from ATM company to A company with effect from such and such by such and such. Sian Sitong Sangtam, a first NEP battalion is hereby reported on duty in 3rd NEP Battalion, Tuinsang, on transfer with effect from 9 November 1979. He is been allotted regimental number 32-23-7 and posted C company of this unit with effect from same date by such and such. Then my lord, in the service book, it para 2.2 efficiency bar. Since he was a regular recruitee trained in transfer, Commandant is pleased to grant to cruise efficiency bar at the stage of rupees such and such from such and such with effect from 1/4/80 in the skill of such and such by 3rd Commandant, 3rd Navy, Tuinsang. Then page 26. That is the annexure. Continuation of paragraph 2.2. Number such and such, the Sanctum company of this unit is hereby discharged from the service with effect from forenoon of 1st April 1991 at his own request. Right, office order dated 3/4/1991. That is it, page 27, type copy is 27A. What happened is that in spite of taking due discharge from the appointing authority, that is the commandant, pension and service benefits were not given to the petitioner. As such, through help of a well-wisher, as the petitioner being illiterate, petitioner applied only on 23/4 of 2019. 1991 is his taking due discharge. But
He was discharged on his request on 1/4/1991.
my lord, yes. So what I'm trying to see is that he didn't know about his right.
It is.
He didn't know about his right to get benefits of his service. That is what I'm trying to say, paraphrase.
Para 4.
Yes. That in spite of taking due discharge from the competent authority, pension and service benefits were not given to the petitioner. As such, through help of a well-wisher, as the petitioner being elected, the petitioner applied on 23/4/2019 to the DGB Nagaland, praying for payment of pension and retirement benefits. However, my lord, this is relevant. However, what happened is that by impugned office letter dated 3/9/2019, written by the Commandant Third Navy Tunsang to AIGB Administration Nakalan Kohima, the same was denied, stating as follows. In inviting a reference to the subject cited above, I have the honor to state that ex-constable number 7 such of this unit who was discharged from service with effect from 1/4/1991. It is on request by order dated such and such. As per available records in the office of it, his GIF, GBF, in left engagement bill have been already prepared from this office. This was not paid. Even till today, it is not paid.
Even today, this
Till today, it is not paid.
not paid.
No. So, as per the available records, they are very sure about it. In this office is GIS, in GBF, in left engagement, bills have already been prepared from this office. However, they are trying to see pension. However, pension in retirement benefit to the said discharged constable does not arise, since he was discharged from service at his own request. That is what the annexure 4 in 5, page 44. That is his application. 45. 45A is the type copy. This is from the commandant. Third enemy, Twinsang. So what we are stating is this, to the EIT administration, Natungan Kohima. Subject submission of the chief report in respect of ex-constable number such and such. Reference page Q number dated 26/6/19. Third, in inviting a reference to the subject cited above, I have the honor to state that ex-such of this unit who was discharged from service with effect from 1/4/1991. It is request by office order number such and such 3/4/1991 in as per available records in this office. In the office, his GIS, GBF, and left engagement bill have already been prepared from this office. However, pension and retirement benefit to the state discharge constable does not arise since he was discharged from service at his own request. Submitted for your such and such. The whole document is enclosed. Then, by impugn of this letter dated 27/7/2021. These are the two challenge later. Written by Deputy Secretary Government of Nagaland to the DGP as follows. What we are saying is that page 46, I may be allowed to read. to the DGB Nagaland Kohima pension and retirement benefits claimed by discharge sergeant such. Sir, I am directed to refer to your letter number such and such and the subject cited above into copy here with the observation of BNER and the matter as stated below. What you are saying is that Rule 26 of the CC's pension rules, 1972, resignation from a service or a post unless allowed to withdrawn in the public interest by the appointing authority entails forfeiture of past service. That is what you are saying. Two, in the instant pension case, the incumbent have submitted an application requesting the department to discharge him from service in thereby entailing forfeiture of his past service. Therefore, we convey to the department that CC's pension rule do not allow grant of pension in this case. So they are silent about GS, GBF in life engagement. Para 5 is what they are stating. So para 5.1, my lord, page 8 of the report. It is not a case of resignation. What I'm trying to say is that page 8 of the report. That it is stated that petitioner did not resign from service, but took due discharge from the competent authority. As such, the impugned office letters are liable to be set aside. 5.2, that once respondents have taken the stance that the petitioner is entitled to GIS, GBF in life engagement, the natural corollary follows that the petitioner has the right to get pro rata pension. It does not stand to reason that the petitioner is entitled to a part of the service benefit, but not other in rest of the benefit as such. A person is a fake case to direct the respondent to be pro rata pension in retirement benefits. Then para 6. What does this CC's pension rule 1972 provides? Chapter 2. What are the general conditions for the pension? Rule 5. Regulation of claim to pension or family pension. One is any claim to pension or family pension shall be regulated by the provision of these rules in force at the time when the government servant retires. That is after completion of the service, or retired, or is discharged, my lord. That is allowed. That is the rule. Or is allowed to resign. My case is comes under discharge. Yes, it might request. But the rule 5 is clear. That is my annexure 7, page 47. Then, para 7 months. That Government of Nagaland Finance Department OEM dated 7/3 of 2001 provides as follows. OEM, I maybe take your lordship direct to the OEM, which is annexure 8. Page 48. Modifications of rules regulating pension and family pension, etc., consequent on introduction of ROP 1999. In pursuance of Rule 26 of Nagaland Service ROP Rules 99, The government of Nagaland is pleased to introduce the following modification in the rules regarding pension, TCRG, and family pension under CC's Pension Rules 72 as application to the employees of the government of Nagaland, hereinafter referred to as pension rules. That is, 1972 rules is followed in the state of Nagaland. Pension, one is pension. That is, bracket A is pension shall be calculated with 50% of P plus NPA if any drawn subject to a minimum of rupees 1275 per month. B is the relevant portion. In case of a government servant retiring under the pension rules before completion of qualifying service of 32 years, that is qualifying length of service. But after completing qualifying service of 10 years, that is what I am trying to increase upon you. The amount of pension shall be proportionate to the amount of pension admissible under the clause A in the amount of pension shall be less than 1275 per month. That is possible because I have not completed 32 years. But 10 years is the qualifying length of service. So I will be less than that minimum amount. Para it. The whole page of the Supreme Court in 1996, 7 ACC 113. Yashwan Hari Khatakar, Appellant versus Union of India. Decided on 19/9 of 1994, laid down as follows. This is para annexure 9, my lord. May I read out the whole lot, my lord? It's very short. The appellant sought premature retirement from government service after he had put in 18.5 years of service in 2 different departments under the central government. Although a request for premature retirement could be made only after 20 years of government service, but the Union of India granted premature retirement to the appellant at the stage when it served the government for 18.5 years. The question for determination is whether the appellant is entitled to any pensionary benefit. That rejected the claim of the appellant. 3. Dr. Anand Prakash, learned senior advocate, appearing for the Union of India, contended that on 7/3/1980, when the appellant was prematurely retired, he had put in 18.5 years of quasi-permanent service. In my case, it is permanent. According to him, to earn pension, this is very relevant, my lord. According to him, that is this Union of India submission. According to him, to earn pension, it was necessary to have a minimum of 10 years of permanent service. Because Hari Khatakar was not in a permanent service. That is what he is trying to say. But he is very clear that 10 years. So necessary to have a minimum of 10 years of permanent service. So the Union of it is clear, very clear about it. It is contended that since the total service of the appellant was quasi-permanent capacity, he was not entitled to the pensionary benefits. There is nothing on the record to show that as to why the appellant was not made permanent, even when he had served the government for 18.5 years. It would be travesty of justice if the appellant is denied the pensionary benefit simply on the ground that he was not a permanent employee of the government. The appellant having served the government for almost 2 decades, it would be unfair to treat him as temporary or quasi-permanent. Keeping in view the facts and the circumstances of the case, we hold that the appellant shall be deemed to have become permanent after he served the government for such a long period. The services of the appellant shall be treated to be permanent capacity and shall be entitled to the pensionary benefit. We allow the appeals to decide the judgment of the tribunal in direct the respondent to treat the appellant as having been retired from service on such and such after serving the government for 18.5 years, bracketed more than 10 years of permanent service. Inshallah, in as such, his case for grant of pension be finalized within such and such. The appellant shall be entitled to all the errors of pension from the date of retirement. Then, what I'm trying to see is that 8.1 in the above case referred, Katakar, the appellant was not holding a permanent post or capacity was granted. Pre-major retirement, even then the Supreme Court directed the respondent to treat the appellant having retired from service and such after serving the government for such and such bracketed more than 10 years of permanent service in as such. His case for grant of pension be finalized within such and such. In the case of the present petitioner, he was holding a permanent post and had completed 10 years of service. As such, he is entitled to pension and retirement benefits from 1/4/1991. 9. That the division bench of the Supreme Court, that is 1994 SCC Supplement 2, 548, Pratuman Kumar Jain versus Union of India, decided on 11 July 1994. Para then, that is annexure 10.
Yes, yes, I will peruse this one. You just see the gist of the case. I mean, I will go through the case you have already read about.
Yes, I've quoted 10.
Para 10.
Yes.
Yes.
It is not disputed that the appellant had more than 10 years of service under the federal government. That's all. Because Rule 49(2) is clear about that. Then, this, of course, this one deals with his service would count as qualifying service for pension if the provision of Rule 13, that is, commencement of qualifying service, and 49 of the rules are satisfied. The relevant portion of Rule 13 and 49 are as follows. 13. Commencement of qualified service subject to the provision of these rules. Qualifying service of a government servant shall commence from the date he takes charge to the post to which he is first appointed, either substantively or in an officiating or temporary capacity, provided that officiating or temporary is followed without interruption by substantive appointment in the same or another service. Mine is a direct recruitment. 49(2)(b), of the pension rules. The amount of pension arrived on the basis of the above slabs will be related to the maximum qualifying service of 33 years. For government servant who at the time of retirement have rendered qualifying service, my lord, of 10 years or more, but less than 33 years, the amount of their pension will be such proportion of the maximum admissible pension as the qualifying service rendered by them years to the maximum qualifying service of 33 years. A few illustrations are given in Annex 1 to this poem, para 13. We therefore hold that the applicant has been appointed in a substantive capacity against a permanent post of assistant meteorologist and is therefore entitled to pro rata pension. In my case, also it is pro rata. In other terminal benefits like JS, GDF, leave engagement, the already prepared, not paid. Under the government, then we direct the respondent to compute and pay the pension in other terminal benefit due to the appellant under the rules in all other relevant orders and regulations within 3 months of the receipt of this judgment. The appellant shall be entitled to 12% interest on the errors of payment to which he becomes entitled as a result of this judgment. 9.1, the Pratoman Jain, the tribal denied him pension on the ground that appellant was not a substantive employee of the central government. Whereas the present petitioner is a permanent employee, as such having completed 10 years of service. The petitioner has the right to get pension in other retirement benefits. Parathan, the pension is a matter of right and cannot be treated as bounty. The law clearly casts a duty upon the employer to pay pension to its employee as such. It is the duty of the respondent to discharge their bounden duty, which they fail miserably to do such present in the page is for direction by this another. So I am impugning page 13. Office letter dated 3/9/2019, that is page 45. Written by the commandant. Of course, I cannot challenge the whole lot because they are very clear that JGD in life engagement. However, I'm challenging to the said portion of about the pension. Then, impugn office letter dated 27/7/2021, page 46.
We have already seen, don't repeat. We have already seen.
Malo,
Don't repeat, we have already seen this one.
Malo, that's all. Malo, in the affidavit, you are saying that he's not entitled because of rule 26. Malo, here is one interesting aspect, how he took the charge. That I've given in para 3 of my writ petition. That after serving for 14 years, 11 months in 3 days, the petitioner approached the appointing authority, that is the commandant third in Navy, on such and such for discharge due to what? Due to his father's illness. His father was the head Kangura. In Nagaland, there is a Kangura. Both the constable are issued uniform, khaki. Kangura are issued red blanket. Both are authority in the police under the state of Nagaland, which are annexed. In my affidavit in reply, which says that is as per that is rules for the administration of justice in police in Nagaland. That is 1937 rules. it says to police. To be the police of the state of Napoli shall consist of a regular police force of the state in the rural police consisting of Mosada, Kongura. In my case, it is Kongura.
So your main reason for praying your discharge on request was that you are to discharge the duty as a Gauhati.
Mala.
So one hand you are praying, you are also claiming that you should be appointed as an Gauhati. So that's why you have got made a request before the authority concerned to
Mala.
discharge you.
Yes.
Then so you're taking double benefits.
Yes. But in my application, I didn't mention about all these things. Application was not drafted by me. It was drafted by the.
Then your application was very tactfully.
No. No.
Because you have not brought all these things
No.
before the.
No.
That you are going to discharge your duty as an
Yes.
Gauhati.
Yes. Yes.
Those were not there.
No, it is not there. Then, my lord, I includes another ruling in my affidavit in reply, my lord. That is page 10, annexure 4.
এটা খুলি গেল নাকি? খুলি গেল। Page 10 না?
My lord.
এটা খুলি গেছে না? This is whole actually. Somehow it is, I mean, इसको ऐसे बांधना है. Has to be tagged here. This is one. So you're saying page 10?
Yes. 2013 5 GLD.
Page 10 होना है. For sure.
2013 5 GLD itu. Yes.
Yes, page 10 where you have cited a decision of this court.
Malord.
Yes.
Malord, in this case, by paragraph of my AIR, service law, pension qualifying service requirement of having 10 years of qualified service in regular capacity for pension rule. This is Assam pension rules. Even if there is something which will make the employee to suffer, it can be relaxed. That is what I'm trying to see, which is exactly in the '77 rules. It power to relax. That is authority is given. Even without that, Manor, 49 is clear. Rule 5 is clear. That's my submission, Manor. Much obliged.
May I please, Your Lordship? Your Lordship, I would first like to rely on my counter affidavit, Your Lordship, which is.
Counter.
Yes, Your Lordship. It was filed on 8th May 2023, Your Lordship. Yes, Lordship.
You are for respond number, all respondents.
Your Lordship,
Respond number
respondents number 1,
five.
2, 3, 4, and 5. The government. The accountant general is also there, but it's represented by my learned friend and Moses. We are the only two respondents, Your Lordship.
So six, you're six.
From the age, for the age.
We are finding the affidavit, Lordship, because the matter was with relation to the pension. Whether the petitioner is entitled to pension, that's at the government level, Lordship. But since during the course of proceeding, Lordship, I was directed to file an affidavit regarding some certain queries, so I've already filed one affidavit. I'll be relying on that.
Okay, your affidavit in opposition is 1, 2, 3, 4, and 5.
Yes, Your Lordship.
Yes.
Page 2, Your Lordship. Page 2, paragraph 5, Your Lordship. I would first like to read this paragraph, Your Lordship. That paragraph 5, Your Lordship, have you got it, Your Lordship? I would like to read paragraph 5, Your Lordship, with your permission, Your Lordship. That with regard to the statements made in paragraph 4 of the writ petition, the answering deponent does not admit anything which is contrary to records, and further states that the petitioner, after taking due discharge by his own request from the competent authority, the petitioner is not eligible for pension as per Rule 26 of CCS Pension Rule 1972. According to Rule 26 of CCS Pension Rules 1972, resignation from service or post, unless it is allowed to be withdrawn in the public interest by the appointing authority, entails forfeiture of past service, Your Lordship. In the instant case, the petitioner submitted an application requesting the department to discharge him from service, thereby entailing forfeiture of past service. An individual who has severed his relationship with his employer by way of resignation cannot claim pension unless he has retired from service or superannuation or on invalid and compassionate grounds. An individual can also take voluntary retirement on completion of 20 years of qualifying service. The benefit of voluntary retirement can be availed only after completion of 20 years of service, not 10 years. The relationship between the parties have been terminated on completion of 14 years of service. With such service, the petitioner does not become entitled to the pensionary benefits. Your Lordship, basically our stand is on that, Your Lordship. Since he has taken, since his case is a resignation, Your Lordship, he has already forfeited his past service, Your Lordship. Therefore, the qualifying service will not come into play, Your Lordship. He's saying that he served for 14 years, Your Lordship. When that service is forfeited, Your Lordship, where is the question of qualifying service, Your Lordships? Therefore, the pension is, he's not entitled for pension, Your Lordship. On one hand, he's saying that he has not resigned and just like Your Lordship had noticed, Your Lordship, he's also relying on the same, on this thing, Rule 26, Your Lord. He's saying that he resigned in order to serve as a Gauhati, Your Lordship. So in that regard, Your Lordship, I'd like to take Your Lordship to NCCS pension rule, Your Lordship. Your Lordship, I would like to read Rule 26, Your Lordship. Forfeiture of service or resignation. Resignation from a service or a post, unless it is allowed to be withdrawn in the public interest by the appointing authority, entails forfeiture of past service. And Your Lordship, this is subsection 2, Your Lordship. A resignation shall entail forfeiture of past service if it has been submitted to take up with proper permission another appointment, whether temporary or permanent, under the government where service qualifies. Your Lordship, I would like to also take Your Lordship to Rule 14, Your Lordship, where it talks about service, conditions subject to which service qualifies, Your Lordship.
Rule 14.
Yes, Rule 14, Your Lordship. This will show whether his appointment as a Gauhati is equal to where this para 2, Your Lordship, Rules 26, sub para 2, whether his service qualifies under this, Your Lordship, whether his past service is forfeited or not, Your Lordship. So Rule 14, Your Lordship, I'd like you to read Rule 14, Your Lordship. Conditions subject to which service qualifies. The service of a government servant shall not qualify unless his duties and pay are regulated by the government or under the conditions determined by the government. For the purpose of sub-rule 1, the expression service must means service under the government and paid by that government from the Consolidated Fund of India or a local fund administered by that government, but that does not include service in a non-pensionable establishment unless such service is treated as qualifying service by that government, Your Lordship. His post as a Gaon Bara, Your Lordship, is not a pensionable post, Your Lordship. That's why this Rule 26 sub para 2 will not help the petitioner cause, Your Lordship. And Your Lordship, on 21 of May 2024, Your Lordship, this court had already partly heard the matter, Your Lordship. So on that day, Your Lordship, the court had given me a direction to bring some instructions before the court, Your Lordship. This will also be relevant, Your Lordship. I would like to read the order, Your Lordship. This is the order dated 21/5/2024. Heard Shri I. Imti Longter, learned counsel for the petitioner such and such, representing the accountant such and such, general such. The present petition is with regard to claim for pension and other retirement benefits, while the petitioner relies upon Rule 49 read with Rule 5 of the Pension Rule 1972 pension rules, the respondent have relied upon Rule 26. The Accountant General has also filed an affidavit answering the queries raised by the court, justifying the action not to release the pensionary benefits. This court has, however, noticed that the post-retirement benefit also includes the aspect of gratuity as per Rule 49(1) of the pension rule. For a period served which is less than 10 years, there is a provision for payment of gratuity. Let instructions be taken by MS such and such on this aspect as to whether the petitioner under the facts and circumstances of the present case would be entitled for such consideration. Your Lordship, as per this court order, Your Lordship, I have placed this instruction. So basically, Your Lordship, the issue with regard to pension was already decided. So the issue remained with regard to gratuity, Lordship. So gratuity, with regard to gratuity, Your Lordship, I would like to read it out this instruction, Your Lordship. To such and such, so I made a read out from the paragraph. I am directed to refer to the above stated writ petition and in supersession of our earlier letter number such and such, convey that under the CCS Pension Rule 1972, there is no provision to grant gratuity upon resignation from service under Rule 26. Rule 49, as pointed out in the judgment order, pertains to cases where an employee superannuated from services and not resigned from service. You are request, Your Lordship. This is the instruction, Your Lordship. And Your Lordship, I would also like to rely.
But as per his, petition, if the department was initiating the process of giving him GIS pension, these are they also.
Those are contributory fund, Your Lordship. So whatever he has contributed, we have already given him, Your Lordship.
Those were already.
Yes, Your Lordship, but with regard to pension, Your Lordship. And I would also like to rely on one Supreme Court case, Your Lordship.
Your Lordship, this is, the facts are very similar, Your Lordship. In this case, also the petitioner had resigned, and this is what the court decided, Your Lordship. I would like to rely on para 5, Your Lordship. This is 2005 8 ACC 325, Your Lordship.
Yes.
The relevant, I would like to read out the relevant paragraph, Your Lordship. Para 5, Your Lordship. 2005 8 ACC, Your Lordship. This citation will substantiate the instruction which I had placed before Your Lordship. In order to, para 5, in order to appreciate rival submission, Rule 26, which is the pivotal provision, needs to be quoted the same rate as under forfeiture of service on resignation. Resignation from a service or a post, unless it is allowed to be withdrawn in the public interest by the appointing authority, entails forfeiture of past service. A resignation shall not entail forfeiture of past service if it has been submitted to take up with proper permission another appointment, whether temporary or permanent, under the government where service qualifies. Rule 26, as the heading itself shows, relates to forfeiture of service on resignation. In clear terms, it provides that resignation from a service or a post, unless it is allowed to be withdrawn in the public interest by the appointing authority, entails forfeiture of past service. The language is couched in mandatory terms. However, sub-rule 2 is in the nature of an exception. It provides that resignation shall not entail forfeiture of past service if it has been submitted to take up with proper permission another appointment, whether temporary or permanent, but under the government where service qualifies. Admittedly, this is not the case in the present appeal. Rule 5, on which great emphasis has been laid down by the learned counsel for the respondent, deals with regulations to claims or family pension, Your Lordship, which this rule had been relied by the petitioner, Your Lordship. Qualifying service is dealt with in Chapter 3. The conditions subject to which service qualifies are provided in Rule 14. Chapter 5 deals with classes of pension and conditions governing their grant. The effects of Rule 26, Sub-Rule 1 and 2 cannot be lost sight of while deciding the question of entitlement to pension. The High Court was not justified in its conclusion that the rule was being torn out of context. After the past service is forfeited, the same has to be excluded from the period of qualifying service. Your Lordship, this is important. The language of Rule 26, Sub-Rule 1 and 2 is very clear and unambiguous. It is strike law that all the provisions of a statute have to be read together and no particular provision should be treated as superfluous. That being the position, after the acceptance of resignation in terms of Rule 26, Sub-Rule 1, the past service stands forfeited. That being so, it has to be held that for the purpose of deciding questions of entitlement to pension, the respondent did not have the qualifying period of service. There is no substance in the plea of the learned counsel for the respondent that Rule 26, Sub-Rule 1 and 2 has limited operation and does not wipe up the entitlement to pension as qualified in Rule 49. The said rule deals with amount of pension and not with entitlement, Your Lordship. Same case, Your Lordship. They're claiming pension under Rule 49, Your Lordship. So, Your Lordship, Rule 49 deals with entitlement of pension, Your Lordship. Sorry, Your Lordship, amount of pension, Your Lordship. So, that's my submission, Your Lordship. When he has already resigned, Your Lordship, the past service he has forfeited. So qualifying years won't matter, Your Lordship. So since he has forfeited his services, Your Lordship, pension does not arise, Lord. Granting of pension does not arise, Your Lordship. That's my submission, Your Lordship.
You want to make any submission here only within 5 minutes? I can
within 2 minutes, Lordship. Here's a case of the petitioner seeking discharge from service. Now, Lordship, argument were based before also, Lordship. Now, the only issue that was left for the AG, the two queries, Lordship, by order dated 5th of October 2023, I was directed to furnish information regarding two queries, Lordship. On that basis, I filed my affidavit, Lordship.
5th
of October 2023. I filed my affidavit, Lordship. Respondent number 6.
Yes, we have your affidavit.
Yes, Lordship.
Okay, then.
Lordship, Lordship, we kindly come to page 5. of the affidavit, Lordship, the last page, Lordship. There are two queries from the court, Lordship. Number one, whether Government 7 who has voluntarily discharged from service at his own request after serving for more than 10 years is entitled to pensionary benefits. So, Lordship, our replies, Lordship. A Government 7 who has been discharged, resigned from service on public interest is entitled to pension benefit in public service, Lordship. However, an employee can voluntarily go on retirement after completing 20 years of qualifying services. That is under CCS pension rules, Rule 43. Those Government 7 who quit, resign, discharge from service at his own request is not entitled for pension benefits. So here's not a question of an honorary discharge from service at his own will. So this is our reply to that query, Lordship, from the Accountant General Office. Lordship, query number 2. Whether a discharge from service and resignation from service is one and the same in regard to entitlement of pension. Lordship, this is another query set up by the court, Lordship. In the case of Civil Government 7, the term discharge and resignation from service are treated as same. Discharge and resignation is termed as same. It's not in the military service, Lordship. In both, the term pensioner benefit will be entitled if it's in public's interest. However, there will be no pensioner benefit if the government servant discharged, resigned at his own request. Lordship, that was the two query put on us. Because the tussle is between the petitioner and the government, whether I should be entitled for pension, since I've already been discharged from service. But our specific reply to this is, Lordship, yes, it's very broad. So under Civil Government 7 services, Lordship, discharge and resignation is termed to be same. Had it been in the military service, Lordship, for instance, a person may be medically unfit to serve, then he's honorary discharged, then he's entitled for the entire pension benefit. Or if somebody is skilled in action, then they are given extraordinary pension. There are circumstances, Lordship. But here's the question of discharge. Here's voluntarily. And Rule 26, Lordship, I may not repeat it again. 26 is very clear. Rule 26. That's all, Lordship.
Your Lordship, if I may, one last citation, Your Lordship. This citation is regard to when a person voluntarily retires on his own request, he's not entitled for benefit under the Act, Your Lordship. This is a small judgment, Your Lordship, so just one paragraph.
Much obliged.
Obliged.
We try to get the order by this week only. I mean, otherwise by Friday we are leaving. And the problem is that carrying these records from here to Gauhati, again, it is problematic. So we'll try to pass the order by this week. We'll try. Yes, you clip it. List is over. No, list is over, no? List is over? Any matter left? No. Raining for the yesterday night or since raining only, no? Yesterday morning only, I think.
It might get rain for the whole week.
Yes, but we enjoyed and the
Yes,
the
I
climate.
feel it very cleansing the whole environment.
Yes. Congratulations.